Estate planning might sound like something reserved for the wealthy, but in reality, it's a critical process for every adult. At its core, estate planning is simply creating a clear, legally binding plan for what you want to happen to your money, property, and dependents if you become disabled or pass away. It's your instruction manual for the future, ensuring your wishes are honored and your loved ones are protected. This guide will walk you through the essential components of an estate plan, help you understand the key decisions you'll need to make, and provide a roadmap for putting your plan into action. Why do I need an estate plan? Having a solid estate plan is crucial because if you die without one, a legal status known as dying intestate, the court gets to make critical decisions for you. A judge could decide who manages your estate, who inherits your assets, and even who becomes the guardian for your minor children. A well-crafted estate plan gives you control. You, not a court, decide what happens to everything you've worked for. Protection for your loved ones. It provides a clear game plan for your family during an already difficult time, minimizing stress and potential conflicts. Peace of mind. It gives you the comfort of knowing that your legacy is secure and your family is cared for according to your wishes. When should I start? If you are 18 or older, the time to start is now. An estate plan can be as simple as a basic will, and creating one is one of the most important things you can do for yourself and your family. The core components of an estate plan. An estate plan is more than just a will. It's a collection of legal documents that work together to protect you and your assets in various circumstances. 1. Last will and testament. Will. A will is the cornerstone of most estate plans. It's a legal document that outlines your wishes for the distribution of your property and the care of your dependents after your death. What a will does, distributes your property. You can specify who receives your money, real estate, and personal belongings. Names an executor. You choose a trusted person or institution to be in charge of carrying out your will's instructions. Names a guardian for children. This is arguably the most critical function of a will for parents. It is the only document where you can legally name a guardian to care for your minor children. What a will doesn't do. A will does not control the transfer of non-probate assets. These are assets that pass automatically to a new owner by contract or by law. Common examples include jointly owned property with right of survivorship, life insurance policies with a named beneficiary, retirement accounts like 401ks and IRAs with a named beneficiary, payable on death POD bank accounts. It is critical to review the beneficiary designations on these accounts to ensure they align with your overall estate plan. 2. Trust. A trust is a legal arrangement where you, the grantor, transfer assets to a person or institution, the trustee, to hold for the benefit of a third party, the beneficiary. Key advantages. The primary benefits of a trust are avoiding the public court process of probate and providing more privacy than a will. Key limitation. A trust cannot name a guardian for minor children. Therefore, even if you have a trust, you still need a will. Common types of trusts. Living trust, created during your lifetime to hold your assets. Revocable trust, the most common type of living trust, which you can change or cancel at any time. Irrevocable trust, cannot be changed once created, often used for tax planning and asset protection. Testamentary trust, a trust that is created within a will and only comes into existence after your death. 3. Powers of attorney, POA. These documents are crucial for planning for your own potential incapacity. They appoint a trusted person, your agent, to make decisions on your behalf if you are unable to. Medical power of attorney. Appoint someone to make healthcare decisions for you. This is sometimes part of an advance directive, or living will, which outlines your wishes for end-of-life care. Financial power of attorney. Appoint someone to manage your financial affairs, such as paying bills and managing bank accounts. 4. Letter of instruction. This is an informal, non-legally binding document where you can provide personal instructions and details that don't belong in a formal will. This can include funeral wishes, information about digital assets, social media accounts, online passwords, personal messages to loved ones, navigating estate planning obstacles. When creating your plan, it's important to be aware of 3 potential legal hurdles. Living probate, conservatorship/guardianship. This is a costly and cumbersome court process designed to care for individuals who become disabled without a power of attorney in place. A proper estate plan helps avoid this. Probate. This is the court-supervised process of validating a will, paying debts, and distributing assets. Having a clear will makes probate much faster and less expensive. Dying without a will makes the process much more complicated. Estate taxes, also known as death taxes. These are taxes levied on the value of an estate after death. As of 2025, the federal estate tax exemption is high, but it is scheduled to be cut in half at the end of the year. Many states also have their own estate or inheritance taxes. Proper planning can help minimize these taxes. Putting your plan into action. A step-by-step guide. Decide who gets what. Make a list of your significant assets, physical and digital, and decide who you want to inherit them. Choose your key people. Executor. Who is responsible and trustworthy enough to manage your estate? Guardian. Who would you trust to raise your children? Trustee. Who has the financial acumen to manage a trust? Powers of attorney. Who would make sound decisions on your behalf? Talk to your loved ones. Before you finalize your documents, speak with the people you've chosen for these key roles. Explain why you chose them and make sure they are willing and able to serve. Create and execute the documents. Work with an attorney or use a reputable online service to create your will, trust, and powers of attorney. Sign these documents according to your state's legal requirements, usually in front of witnesses and a notary, to make them legally binding. Store your plan safely. Keep your original documents in a secure place where your executor can find them, such as a fireproof safe or a safe deposit box. This is your legacy drawer. Communicate and share copies. Give your executor instructions on where to find your documents. Provide copies of your powers of attorney to your agents. Keep your plan up to date. An estate plan is not a one-time event. Review it every 3 to 5 years and update it after any major life event, such as a marriage, divorce, birth of a child, death of a beneficiary, or significant change in assets. By taking these steps, you can create a comprehensive estate plan that protects your legacy and, more importantly, the people you love most.